Hi, I'm Jonathan Cappy.
And I'm Garrett Horrocks.
Welcome to Holland Estates. You're listening to episode number 542. Today we'll be discussing the Court of Appeal decision in Harvey and Talon International, which is a fascinating case that deals with limitation periods and real property. But before we do that, and before we get into that case, I think it's important to discuss an earlier decision of the Court of Appeal from 2014, which is the McConnell and Huxtable decision. In that decision, it was a family law case that dealt with a spouse who was claiming constructive trust. And as a result, as part of the unjust enrichment claim in constructive trust, the spouse was claiming an interest in the matrimonial home. And one of the important things that came out of that case, and one of the important issues that was being argued was what was the limitation period that applied with respect to that claim. And if we get into the history of the Limitation Act, and the McConnell case does a wonderful job of going through the history, is that as of the RSO 1990s, there was one Limitation Act that dealt with limitation periods for both real property and for personal property. The legislature decided that they wanted to create a new limitation period regime, which is what we know as the Limitations Act 2002, which really not only expands the scope of the cause of action covered by the Act, because under the old regime, only specific enumerated causes of actions had limitation periods, whereas now it's any cause of action or claim for damages in the language of the statute. And they have now shrunk the limitation period to 2 years. And as I don't want to badmouth the legislature, referring to the McConnell, they have an explanation as to what happened. Because when they created the new act, they didn't take all of those limitation periods covered by the old act and make it into the new one. They ran into difficulties when dealing with the real property section of the old Limitations Act. And they say that they were not comfortable in dealing with the real property part of the statute. And so really, at the end of the day, it's a sort of fascinating discussion in the case, but they basically said, we're not going to change the limitation periods as it relates to real property. We just don't understand it well enough. We don't want to mess this up. And so that's why right now we're in a situation where we've got a Limitation Act 2002 that deals with real personal property and causes of action generally. And then we have the Real Property Limitations Act that deals with claims related to real property and specific causes of action related to real property that are enumerated in the Real Property Limitations Act. And so the question in the McConnell case was, is a claim for unjust enrichment, which is not related to land in and of itself, and a constructive trust, which is a direct claim to an interest in land, is that covered by the Real Property Limitations Act to have a 10-year limitation period? And the court eventually said, yes, it does. And not only that, but it also allowed an alternative claim of damages to be sheltered under that 10 years. Otherwise, you're stuck with a claim for damages, which is 2 years, a claim against real property, which is 10 years, and if you lose your real property claim, you can't assert your alternate claim, which they thought was absurd. And that leads us into more recent decision of the Court of Appeal from 2017. So, Gary, why don't you tell us a little background about the facts of this case?
So this is a bit of an interesting case, very apropos to current political climate, so to speak. So this case was actually two applications consolidated into one hearing at the Court of Appeal, and it concerned two individuals who'd entered into agreements of purchase and sale to purchase condominium units in what was now formerly known as Trump Tower in Toronto. One of the applicants had purchased his interest back in 2005, and the other applicant had purchased hers, I believe, in 2007, so going back about 10, 12 years now. So as part of the agreement of purchase and sale, as is typical in most real estate transactions, both the applicants put down a deposit in order to secure their interest in land. And as happens in a lot of real estate transactions, things change. The developer wanted to make, as I understand it, he wanted to make some significant amendments to the agreements of purchase and sale, and eventually, fast forward 3 or 4 years, in about 2011, 2012, the agreement that both applicants had originally entered into was effectively nowhere near the same as it was when the agreement was concluded back in 2004, 2007, as it were. In that case, or both cases, I suppose, the applicants basically sought to withdraw or to rescind the agreement and recover the deposit that they paid. They were successful at first instance. There were some issues as to whether the language they used in their, I think both of them sent emails to the developer asking for recovery of their deposit. There were some issues as to the language they used and whether that was sufficient.
The court at the end of the day said that the notice itself was sufficient.
Yes.
So that really wasn't the issue before the court at the time. The issue was whether or not a limitation period had expired and what the applicable limitation period was.
So there were several issues at play, and the limitation period issue is obviously with the discussion in McConnell that we had previously. That was the main issue that we want to focus on today, and that's the issue that is most relevant on appeal. So the application judge held, and we believe correctly, that the Real Property Limitations Act is the applicable limitation period, notwithstanding that it was essentially recovery of money. So the court kind of split their analysis into sort of a discrete three-step test. So I guess we'll back up a little bit and sort of explain the relevant section of the Real Property Limitations Act, which is Section 4, that establishes a 10-year limitation period for actions to recover any land or rent. So the Court of Appeal kind of split that into three questions. So was there an action, was there recovery, and was the claim in land? So the first two issues are not necessarily relevant. They were, I think, a slam dunk for the court. There was an action because the Real Property Limitations Act defines an action as any civil proceeding. That was a foregone conclusion. And recovery is defined as not just, as an act.
Let's be gaining through a judgment order.
Yeah,
I mean, that was sort of the simple part. So the question was the action to recover the deposit encompassed by Section 4 of the Real Property Limitations Act?
Right. So,
and as part of the definition of land in the act, in the statute itself, it refers to money to be laid out for the purchase of land.
Right. And the court kind of drew a distinction between McConnell in the sense that in McConnell, the court held that a constructive trust was sufficient to sort of attach the 10-year limitation period, and a constructive trust is a bit of kind of a legal fiction, or it's a bit of a kind of amorphous entity. It's not actually it's not actually a legal entity, so to speak. Whereas
it's not really a cause of action.
It's not a cause of action.
It's a remedy more than a cause of action.
Right. And the court kind of drew a distinction in Harvey and Talon that this was a recovery of a deposit. So it's something that's more tangible. It gives rise to a cause of action. So therefore, I wouldn't say necessarily by the transit property, but if the court's going to hold that a constructive trust can attach 10-year limitation period, and that's a bit of a, again, that's not necessarily, doesn't give rise to a cause of action in and of itself, then a claim for recovery of a deposit should therefore be sufficient just because it's more tangible,
yeah, I mean, I think that's the distinction between McConnell and this case, right? McConnell was a direct claim to an interest in land, and in the alternative, a damages claim. And in this one, there was no claim to a direct interest in land. In fact, they were trying to get out of purchasing this property, but they were trying to recover a deposit laid for the purposes of purchasing land. And we get into the discussion of, well, how close do you have to be to a claim in land to get caught and have the benefit of a 10-year limitation period versus a 2-year limitation period? And certainly, because if you're making a claim for damages, it's 2 years.
Right.
If you're making a claim for recovery of land, it's 10 years, and that's a significant difference.
Yeah, and that's something that the Court of Appeal actually specifically notes in the decision.
Yeah, I mean, what they say is that if this claimant had been primarily seeking damages for breach of contract, then her action would have been statute barred. And the court even says this would be true even if the claim for damages incidentally related to real property or the condominium. The claim for damages does not fit within the definition of land in the Real Property Limitations Act.
Right, so that kind of highlights the importance of, I guess, proper pleadings and sort of pleading the case that you want to make. Because I suppose the applicants in both cases could have easily pled for damages for breach of contract, and sort of an unwitting lawyer might not have realized the difference. So I think this case is important. It sort of is important to highlight the importance of sort of pleading the case that you want and ensuring that you're seeking the appropriate remedy for the facts.
Yeah, and then the court makes a big distinction and an important distinction between return of a deposit versus damages.
Right.
And if this had been a claim for damages, it would not have been under the Real Property Limitation Act. But because it was for a deposit, a return of a deposit, it does fall. And I think that, in estate cases, there is always, or for the most part, real property within an estate. I mean, most people, when they pass away, have a home or a cottage or a condo or something. And we need to deal with limitation periods with respect to claims as against and for recovery of those properties, whether it's 10 years or 2 years. And these cases seem to be suggesting if it is a claim for an interest in that property being asserted as against the estate, then it is 10 years. How that reconciles with the Trustee Act in 2 years, these cases didn't tackle.
Mm-hmm.
That's something certainly that you have to be aware of.
Yeah, so I think it draws a distinction between what is a deposit and what is a claim for damages, as you mentioned, and I think that's important both for for the lawyer, but also for the client to understand, or sort of keep an eye on what the lawyer's doing, and sort of make sure that they're pleading a proper claim, or they're pleading for the proper remedy, and just keep that distinction in mind.
It's certainly something to think about. But I think that concludes our discussion for today. Something great to think about. It's something certainly we encounter all the time, and worth thinking about when you're dealing with these files.
Mm-hmm.
So until next time, we want to thank you for listening. I'm Jonathan Cappy.
And I'm Garrett Horrocks.
Should you have any questions, please email us at webmaster@hollandhall.com or leave us a comment on our blog.